As we mentioned, the Trump administration is mobilizing and expected to deploy U.S. Marines to the streets of Los Angeles in response to immigration protests. This follows the president's calling up of the California National Guard against the wishes of the state's governor, all of which raises all sorts of legal questions. And joining us now is Stephen Montoya, a partner at Montoya, Lucero, and Pastor. Good to have you here. Well, we got a lot to talk about. I know the National Guard thing is fascinating from a constitutional aspect from long ago, and we were talking beforehand about this. But this business of calling up active duty troops, can the president call up federal troops on U.S. soil?
Yes, but he has to use the right law. And as of last night, he wasn't using the right law. He was using Title 10 of the United States Code, Section 12406, which only authorizes him to call out the National Guard. And moreover, once he does call out the National Guard, everything goes through the governors of the states, or in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. That didn't happen in this case. Calling out the Marines are not the National Guard. Moreover, his generals or somebody else is in charge of the National Guard, not the governor of California. That also violates the letter of this law. However, there's another law, a more famous law, or a more infamous law, depending upon your perspective, and that's the so-called Insurrection Acts. Under the Insurrection Acts, President Trump doesn't need the governor's permission, and in fact, federal authorities would be in charge of either the National Guard or some other armed forces, which would include the Marines.
Okay.
But he hasn't cited the Insurrection Act.
Yeah, I want to get back to the Marines real quickly here,
Sure.
because I'm old enough to remember when late night talk shows would talk about posse comitatus. Now, the government was ready to send in troops to take over everyone's rights and just, trample on everything and everyone.
Understood.
Council for Foreign Relations and the Trilateral, they all kind of ran together. This was back in the day. This is the real thing right now. How does that law apply to the president putting active duty U.S. Marines in an American city?
Well, honestly, it really doesn't. The Posse Comitatus Law of 1878 is a fascinating law. As the year suggests, 1878, it was passed right after Reconstruction, when the South was successfully ridding itself of the Union Army that was making sure the laws, including the 13th and 14th Amendment, were fairly enforced. But part of the Compromise of 1877 actually required the federal troops to leave the South, and that's why that law was passed. But that law was true even before, the principle was true even before it was passed, that the United States military could not act as law enforcement officers. And that goes all the way back to the Revolutionary period. Remember, Ted, the American Revolution was initiated in part protesting a standing army, the standing army of King George that occupied the 13 colonies, right? Mm-hmm. And so the colonists were very distrustful of standing armies, and so were the founding fathers. And that's why, even though the Constitution itself authorizes calling up the militia in cases of insurrection, there were certain very, very stringent procedural safeguards required. First of all, only Congress could call up the militia, which would, and command of the militia would be transferred to the president. But before it was transferred to the president, either an associate justice of the Supreme Court or a federal district court judge had to certify that, in fact, it was an emergency. So all three branches of government had to participate in calling forth the militia under the first Militia Act, which later morphed into the Insurrection Act.
Okay, I'm not remembering, and I'm not seeing any reports of that happening. I'm seeing
it didn't happen. It didn't happen because that law actually, the founding generation were so suspicious of standing armies and a standing militia, that the law automatically expired after the passage of 3 years, after General Washington, who was the President Washington, who actually presided over the first calling out of the militia, after he did his work in quashing the Whiskey Rebellion without firing a shot, he actually dismissed the militia early, and it was passed again in 1795. And the 1795 law, like the present law, didn't have those procedural safeguards to make sure that it stayed in the right lane.
Okay, if you're not in the right lane, and California's governor and attorney general both say that the president was not in the right lane in calling up the National Guard over the governor's objections, they filed a lawsuit. Do they have a case?
I think they do have a case. It's a difficult case, though, because even though, and it depends upon how the United States answers the case. Really, because the insurrection law, as presently constituted, allows calling up the armed forces of the United States rather than merely the National Guard, which is the successor to the militias. Because the Insurrection Act allows that, really President Trump did what he could do, and there's a long tradition of that people have forgotten about that. President Eisenhower federalized the National Guard, and actually the Army flew in to Little Rock to make sure integration under Brown versus Board of Education was effectuated. It's happened over and over through in United States history. Actually, in the late 1890s, remember Eugene Debs, the famous labor activist? They called out the Army to take care of one of the protests he led, and guess what? It was affirmed by the Supreme Court.
Okay, but in this case, does the president have to prove, the administration, the Defense Department have to prove, A, that there's an insurrection, B, that it's an emergency, C, that it is an invasion? Those are the words that the administration keeps using to justify these kinds of actions.
Well, all he has to do is, under the Insurrection Act, if he cites the Insurrection Act in defense of what he did, all he has to do is prove that unlawful obstructions make it impracticable to enforce the laws of the United States. An unlawful obstruction is not an insurrection, it's not an invasion. Actually, it's ill-defined. That's one of the problems with this law.
It could be defined as keeping ICE agents from doing their job.
Yes, or attacking federal buildings or attacking federal property. Those are very serious felonies by anybody's estimation. Whether or not you need the United States Marines to act as the police force in that context is a completely different matter.
Wow. All right. Stephen Montoya, holy smokes, we could go on all day about this because it's fascinating. The historical aspects are fascinating, and we don't even know what's going to happen next as far as Los Angeles is concerned. And in other cities, the president's talking about getting National Guards from other states to come over to Los Angeles and help.
He is. I think what's important to remember is using the military to enforce domestic law is a stride in the direction of a police state. That's why the Founding Fathers were against it.
Stephen Montoya from Montoya, Lucero, and Pastor, partner there, friend here. Good to have you here.
Thank you, sir.